Welcome back to Good Law, Bad Law. My guest on today's episode is Vanderbilt Law School Associate Professor of Law, Jennifer Shinall. She is an expert on pregnancy discrimination, and we're talking about a new federal lawsuit against one of the largest law firms in the country, Jones Day, brought by two lawyers of the firm who together had a new child and alleged that they were discriminated against by the law firm in terms of the law firm's parental leave policy. So Jennifer and I are talking about parental leave, how it can be discriminatory, how its application can be unequal as between men and women, fathers and mothers, and how this can then in turn lead to all kinds of problems involving retaliation, loss of advancement, the so-called mommy track, and even an impact on gender-based pay gaps. This is a really important issue that affects not only lawyers at big law firms, but workers at all levels of the economy, at all levels of pay, and all kinds of industries in our country. What is going to happen with this case, and what does this say about where we're going as a society in terms of how we regard new parents, their responsibilities to children, and what impact that can have on them in their jobs? A really important conversation, a fascinating conversation. Stay tuned. Today we are talking about the way men and women are treated differently in businesses when it comes to parental leave policy in particular, that is when parents have children, and how businesses, in this particular case, one of the largest law firms in the country, treats men and women differently, at least as is alleged in a major federal lawsuit that's just been filed. And to help us understand these issues a lot better is my guest today, Jennifer Shinall. I hope I'm pronouncing that right, Jennifer.
It's Shinall.
Shinall, okay.
Close.
Okay, good. Jennifer is an associate professor of law at Vanderbilt Law School. She received her undergraduate degree from Harvard and her law degree and Ph.D. at Vanderbilt. And Jennifer, I understand from looking at your bio, your background, that issues of gender discrimination, particularly with a focus on the impact of pregnancy on women and men in their employment and with respect to their benefits, is something that in particular you have concentrated on in your research and in your teaching. So first of all, thank you very much for being on Good Law, Bad Law. I want to thank you as we get started today.
I'm glad to be here.
I'm sure I've left something out, but if maybe you want to add to your own background, in particular on this issue, and how you came to this issue, and how this is an issue that for you has been a subject of particular interest and focus for you in your work.
Sure. So much of my research focuses on the intersection between gender and health issues. So I've done quite a bit of research on disability, and particularly disability in the workplace, with a special eye towards special issues for women that arise with respect to disability in the workplace, but also just health issues and how health issues can have different implications depending on your gender. And so pregnancy is right in my wheelhouse in the sense that, there's perhaps no health issue more gendered than pregnancy. And so I have done some research on pregnancy discrimination. Particularly, I wrote an article last year looking at what we know empirically about pregnancy discrimination. So I'm an economist as well as a lawyer, and so a lot of my research is looking at labor market data, thinking about whether the laws we have on the books are working, or whether there's been any empirical indication that they're working in the data, and also thinking about how laws might need to be reformed to help some of our workplace discrimination issues be remedied, or to help laws work better to help historically disadvantaged populations. And what we know from the data, with respect to pregnant women, is that employment numbers are much worse for pregnant women than for non-pregnant women, and there seems to, despite the presence of things like the Pregnancy Discrimination Act and Title VII, pregnancy discrimination seems to still be a problem in the workplace, although it's particularly a problem for lower wage, lower income individuals, which is, of course, not the plaintiffs in the Jones Day lawsuit. But pregnancy discrimination, despite federal protections, does seem to be alive and well in the workplace.
Well, and of course, you said this is a uniquely or especially gendered issue, and probably to most people that seems so obvious because pregnancy literally is something that only happens to women, although parenting is something that both men and women know in same-sex relationships, in opposite-sex relationships, all the same, and attitudes towards both, towards pregnancy among women in the labor force and attitudes to parenting and the needs of parents, particularly in the period right after a child is born, perhaps have been slow to catch up with attitudes that many more people have today, many more progressive attitudes towards those things. And I take it that that is really at the heart of what is at issue in a pair of federal lawsuits against Jones Day. Again, one of the biggest law firms in the country won a class action lawsuit that was filed earlier this year, brought by 6 female attorneys who claimed that they were discriminated against on the basis of gender in what they describe as a fraternity culture at the law firm, and more recently, a federal lawsuit brought by a couple, a man and a woman, both of whom were lawyers employed at the firm and who are alleging that they were discriminated against because of the firm's parental leave policy. So I wonder if we could start so that we could get into the broader issues involving these concerns by laying out a bit of the facts of this Jones Day case. And I guess we should also say right off the bat that Jones Day, of course, is contesting these lawsuits, denies the allegations in both of the cases, and they are both pending in court. But what we know of the facts as alleged by the couple who filed the most recent case, Mark Savignac and Julia Sheketoff. Can you give us the background on the case and what the issues are that they're raising?
So, from what I understand of their allegations, there's several allegations wrapped up in Jones Day parental leave policy. But the basic idea is that Jones Day gave birth parents or primary caregivers different amounts of leave than the non-birth parents. And so the allegation is that the female in the couple who had a child got, I believe, 18 weeks of leave, and the male was not entitled to the same amount of leave. So, that's one issue as to whether, to the extent that leave policies are distinguishing based on gender, whether that's okay under something like Title VII. But then the other sort of issue that comes up, another allegation within this lawsuit, is the retaliation issue. So one of the allegations by the male parent who was terminated was that all he did was question the policy, that he, questioned whether it was legal under Title VII for males to get less leave than females under a parental leave policy. And, he alleges that as soon as he questioned the policy, he was terminated. There's kind of there's sort of a status-based discrimination claim under Title VII based on the actual policy being discriminatory in and of itself, and then there's also a retaliation claim that just by questioning the practice that he was unlawfully retaliated against. And then the other sort of curious thing I have to say about the Jones Day policy, from what I understand, is that I believe that birth parents got 18 weeks of leave, and I believe that the non-birth parents got 10 weeks of leave. But then also in the background of this policy, that I think maybe makes Jones Day's case a little bit harder, is that adoptive parents. Now, these parents did not adopt a child, but what we also know about Jones Day's policy is that if you had adopted a child, that you were entitled to 18 weeks of leave, I believe, as long as you declared yourself the primary caregiver.
Right, and that raises an important definitional question, I think. So, my understanding, and I've read a number of articles. There was a big write-up on this case in the New York Times very recently, for example, were that whether biological mother or biological father, in this case, they're both lawyers, and by the way, both former Supreme Court clerks, which is a very prestigious credential to have, in many law firms around the country would be very happy, generally speaking, to have a former Supreme Court clerk as a lawyer in the firm. And Jones Day, again, is a major law firm employing hundreds and hundreds and hundreds of lawyers around the country, and indeed in offices around the world, we should say. But it's my understanding that whether biological mother or biological father, under the firm's parental leave policy, you get 10 weeks of paid leave. But in addition, you can qualify for 8 weeks of disability leave if you are the mother. And
right.
I guess the idea is that if you have it's theoretically possible that you could suffer from some kind of disability relating to having been pregnant, if you had a C-section, for example, or you had some kind of complication, and that could be a justification for additional leave for the mother. But apparently, at least as they are alleging in the lawsuit, the law firm doesn't really require any kind of actual disability in order for the biological mother to qualify for that additional 8 weeks of leave. So in effect, they're saying biological mothers get 18 weeks, but biological fathers only get 10 weeks of paid leave. But both have to, and here's the thing I wanted to fold into this and have you explain for us as well. You have to be able to say that you seek to be the primary caregiver. And I mean, what does that mean?
Yeah, it's not the best structured leave. So there's a couple of issues there. So, let me first say that, I don't think that allowing additional leave for biological mothers, at least to some extent within reason, is particularly controversial or a violation of Title VII. What we know, especially since the 2008 amendments to the Americans with Disabilities Act, is that, the federal courts have been much more amenable to so-called temporary disabilities, and the case law with respect to pregnancy and pregnancy-related disabilities is much more positive all that to be said, as somebody who not only works in this area but has also had a child, I mean, even if you have a very non-complicated vaginal delivery, having a child physically disables you for at least a couple of weeks. I mean, most even normal deliveries, the mother is on some sort of movement or exercise restriction for at least 2 weeks, but really 4 to 6 weeks is pretty typical for most obstetricians. So to the extent that we give a little bit more leave to somebody who physically went through childbirth, especially if you're talking about a childbirth that was more complicated or certainly resulted in a C-section, I don't think that it's particularly controversial or bad policy or certainly not illegal because of the ADA to give birth mothers, let's say, 6 more weeks, even 8 more weeks for something like a C-section. Because like I said, most OBs put birth mothers on physical restriction for those first 4 to 6 weeks after a delivery.
Yeah, I mean, that could even be seen as generous on the part of an employer.
Right. That's exactly right. So I don't think that, I think that, to the extent that we have employers like Jones Day giving these, electing to give these generous paid leave provisions, it doesn't run afoul of Title VII to give a more generous leave provision to a birth mother than a non-birth parent, just simply on the fact that childbirth is at least temporarily disabling. And so that part of the leave provision could be viewed more as a disability-related accommodation than a parental leave provision. That being said, to the extent that we start wrapping this all up in the idea of primary caregiver and who's the primary caregiver and the gender of the primary caregiver, that's where it gets a little bit more problematic.
Okay, why is that? Tell us why that is so.
Well, because, I mean, look, we, to the extent that how much leave you get depends on you declaring yourself a primary caregiver and doesn't have anything to do with actually being disabled by the actual physical act of childbirth. Look, we know that even to this day, even as, sort of people, as people get more progressive and there are more stay-at-home dads, that, the strong majority of primary caregivers in this country are women. We also know that to the extent that employers grant leave and even paid leave, that men are much less likely to take the full extent of their leave than are female caregivers. And, we also, I think that this policy I think it's technically legal to only allow that an employer only allows a quote unquote primary caregiver to take the full extent of leave. I think technically that's probably legal, but then again, I think that in most workplaces in this country, the data certainly suggests that the only people who are going to stand and declare themselves the primary caregiver, sort of given the norms of society and certainly in most workplaces, are women. Because there's certainly a lot of survey evidence to indicate that men who declare themselves to be the primary caregiver or take even the full extent of leave that they're entitled to are, subsequently feel like they're retaliated against or looked down upon when they come back to work.
Well, right. And let's leave to the side just for the time being the allegation on the part of the father in this story who alleges that he was retaliated against, meaning he was fired for raising concerns or even complaints about the policy and how the policy was being applied in their case. let's leave aside that, because that's kind of literal retaliation.
Right.
But it seems like these types of policies can raise all kinds of more subtle forms of retaliation that are going to be harder to get at, because a policy can be perhaps non-discriminatory on its face, on the language of the policy, but nonetheless discriminatory in its application. And in a law firm or in any big company where performance is really strongly tied to compensation, to bonuses, to advancement, certainly in a law firm, performance is strongly linked to a lawyer's ability to make partner in that law firm. In other words, to advance within the law firm. And if a parent, first of all, as you suggested, claims all of the leave that they may legally be entitled to, or that a policy may allow, that, and if they have to declare I'm a primary caregiver, can't those types of designations really be used to count against an employee? In this case, again, a lawyer, but nonetheless an employee. Any business, it would be the same, I would think, because it could be seen as the person not being fully committed to their job.
That's right. So, in most major law firms, there's certainly rumors about there being a mommy track already. That is the idea that once you decide to have a child and, you take the full extent of your leave or any leave at all, that you're essentially rerouted onto a different track that does not advance towards partner. And, by forcing a parent to declare themselves a primary caregiver, that certainly seems to be forcing somebody to declare themselves as now going on the mommy track and not the partner track. So it certainly reinforces a lot of stereotypes out there about what working at a major U.S. law firm looks like, and how having a child and certainly taking seriously your responsibilities as a caregiver for that child may prohibit you from making partners.
Well, right. I mean, I've been a lawyer for a long time now, and I can certainly remember back what I guess some people would consider a generation ago at this point, certainly more than 2 decades ago, plenty of people I knew who, if they were a new father, they would often be back to work, sometimes even the same day. They might even stop by the office on the very same day their child was born, certainly within days of a child being born. And on the other hand, women who had a baby and would come back to work, and they would get looks and even comments from their supervisors, from their male partners in particular, sometimes even from female partners, suggesting, what are you doing here? Why are you even, the expectations of men and women based on stereotypes relating to parenting a new child often had a very, very powerful impact on the way those individuals were viewed, and no doubt the way they were treated in terms of advancement, in terms of compensation, in terms of opportunities. Would you be given an opportunity on a big case, let's say, where that case might involve travel? Right. And women I know personally who may not have been given the same types of opportunities because it was assumed that a new mother wouldn't travel for a case, whereas it was assumed that a man would, even if the man felt that he had, primary responsibility or shared primary responsibility for a new child. I mean, those problems haven't gone away in the year 2019.
That's right. And, one thing that we know, most of our data on how parental leave works in practice and paid parental leave, a lot of our best data comes from outside the U.S. because, of course, other than a handful of states that are starting to enact paid parental leave, there's no, certainly nationwide paid parental leave in the U.S. But, one of the things that we know is that even in places that provide generous paid parental leave for both parents, the men don't take the full extent of their leave, even in other countries. And the only way that you can get men to systematically take the full extent of their parental leave is that if you provide some sort of incentive, or it's like a use it or lose it, or you sort of further incentivize men to take the full extent of their parental leave, because it's a problem in the U.S. and it's a problem outside the U.S. that gender stereotypes continue to persist, and there's a real fear, and in some cases a well-founded fear by men that even taking advantage of the leave that they're entitled to is going to backfire on them eventually.
So, and I mean, we're talking about a big law firm here, but I note as well, again, referring to this article I read it this morning again in the New York Times, that there's reference to a similar case having been brought against CNN a few years ago, a case that apparently was settled before it ever got to court. So we're not just talking about big law firms, lawyers, trying to climb the ranks up towards a partnership in a law firm. I mean, is this something that you see from your research and from the data that you look at that does exist beyond just the legal industry, and how widespread do you think the problem is?
So it exists in the progressive firms, whether that be a firm in the legal industry or some other industry. The problem that exists in progressive firms that provide paid leave provisions to begin with, that are go above and beyond their what they're required to do under something like the Family and Medical Leave Act. So it's not surprising that a progressive news organization like CNN would provide generous paid family leave, or certainly more generous paid family leave than they're required to do under law. The problem is that from a sort of practical HR perspective, trying to figure out how to structure these provisions in a way that takes into account that the physical health realities of having a child, of childbirth, are real. And so, some of the leave provision for the birth parent is frankly going to be more like disability leave than caregiving leave. So trying to take that into account without running afoul of either Title VII, which prohibits gender and pregnancy discrimination, or the ADA, which prohibits disability discrimination. And trying to come up with a practical, workable policy that satisfies both is not straightforward, and it's not easy. Because going back to thinking about the Jones Day suit, in some ways their argument seems to suggest that if a birth parent wants additional leave other than the sort of 10 weeks guaranteed to all parents, that, it seems that the plaintiffs think that it would be a better policy for the birth parent to have to document that they needed additional disability-related leave. And I don't think that that's a great HR policy. I mean, again, as somebody not only who works in this area but who's had a child, I can tell you that the last thing that you want to do right after you give birth to a child is document, how much disability you have and send in a form to your employer.
Right.
So
And probably most employers don't really want to get involved in those details either from the employer's perspective.
That's right. I mean, employers and HR already have to deal with enough forms just to comply with the Family and Medical Leave Act, let alone additional documentation to try to figure out, how much leave somebody else is entitled to. So I think the real key is, to the extent that employers are going to provide additional disability-related leave for the realities of childbirth, they have to come up with a number that's going to, make sense perhaps for your average pregnancy, childbirth, delivery, and then if somebody needs more disability-related leave, let's say because they had a C-section, then they would, then they might have to document a need for additional leave.
But that in that situation, say where somebody had to have surgery in connection with childbirth or had some complication that required hospitalization, maybe, I don't know, they developed an infection and had to be in the hospital because of that, let's say. There's no reason why that has to even be considered a gendered disability that is a pregnancy disability. Is there? I mean, if somebody has an infection and they're in the hospital, what difference does it really make if the reason for that extended hospitalization is because it's related to childbirth as opposed to any kind of surgery where you can develop an infection? Or, I mean, you see what I'm saying? Does that have to even be a parental based policy or a childbirth or a pregnancy related policy? Can't businesses avoid the issue of the unequal application of that additional time simply by offering medical disability, whatever the medical disability might be from whatever cause it might arise, and apply that equally to men and to women?
Sure, absolutely. I think, I would caution, though, that there's going to be some medical related disability with every pregnancy. So to the extent that, yes, I completely agree that, there's no reason to make, to the extent that an employer is providing short-term medical disability leave, there's no reason to make it gendered. And maybe that's the best way to sort of solve this issue or this concern about the person who actually gave birth to the child needing more leave than the person who did not give birth to the child. That being said, I think, sort of my caution would be that pregnancy is really common, childbirth is really common, and to the extent that we know that, every pregnant woman, even if she had the easiest childbirth and delivery in the world, needed 2 to 4 extra weeks to physically recover from that, why would we make employers document? Why would we make either both employees and employers go through this sort of documentation process that's involved in medical disability leave for any other type of disability?
Well, I guess because it seems that the issue that this Jones Day lawsuit and others similar to it, the issue raised is the unequal application of the policy, that if something's going to be offered to the birth mother, it ought to be offered equally to the birth father. Some of that may be medical related. I mean, but some of it may relate to other needs that new parents have that I think science now recognizes as being pretty important to the growth of a child, which is bonding time with the parents, and providing that if you're going to provide a benefit, one of the reasons you provide a benefit, and that especially a generous benefit, is because you're trying to compete with others in the same industry because you want to attract talent, you want to attract the best people to your business, to your law firm, if in the case of a law firm. And why wouldn't you be encouraging both parents, as apparently they do quite generously, as you pointed out earlier in this Jones Day case, with regard to adoptive parents? I mean, there's no distinction made, in that scenario. And there's no, if you're adopting a child, of course, obviously, physically, you're not going through anything to do with childbirth itself, but you certainly want to be there to bond with that new child, and we know how important that is. So why wouldn't we look to treat parents equally with regard to leave, regardless of gender, even though pregnancy itself is, as you say, obviously gendered for biological reasons?
So I think that's right. I think, to me, the two most problematic aspects of the Jones Day policy for Jones Day are precisely what you pointed out. So, I think, number one, to the extent that Jones Day is arguing that this extra 8 weeks is about physical disability of childbirth, that argument is difficult to make, and given the reality that they are also giving the extra 8 weeks to adoptive parents. So it's hard to square those two arguments. I also think what's problematic is to the extent that Jones Day is trying to justify this extra 8 weeks based on the physical realities of childbirth, I don't know that 8 weeks is the right number. I think it's, certainly, look, if you have a very complicated delivery or a C-section, you are probably on physical movement restrictions for 8 weeks. But if you have a normal delivery, 8 weeks is a long time, and is often double the time that most women are on, again, physical or movement restrictions for a normal childbirth. And so, to the extent that the allegations are true that Jones Day is just sort of automatically giving 8 weeks to a woman who has a child without sort of any documentation otherwise, then it starts to look a little bit more, assumptions about gender and, who should be at home and who should be the primary caretaker, and less attached to the sort of disability-related aspect of child.
Right. And to be clear, 8 weeks in the case that we're talking about is 8 additional weeks because both parents get, as a matter of course, whether they use it or not, 10 weeks, regardless of whether you're the birth mother, the birth father, or an adoptive parent. But only women in this policy, only birth mothers in this Jones Day policy, have the potential to get an additional 8 weeks if they have a disability. And again, they don't, apparently, according to the lawsuit, they don't ask, for any documentation or evidence or a note from the doctor or anything like that to support the request for those additional 8 weeks, just given. So I said we would put to the side the retaliation issue, and it's on one level, at least, again, as alleged, and again, to be clear, Jones Day denies the allegation. They say they did not retaliate against the father, who raised questions and concerns about this unequal application of the parental leave policy. But he at least is alleging in the lawsuit that he was at home a few short weeks after their son was born, and he got an email saying that he was fired immediately, effective immediately. And is claiming retaliation based on having been fired. But it seems to me the retaliation issue, which has a very hard edge to it, I mean, it's literal retaliation that he's claiming in this case, raises again the broader question of the ways in which both men and women who are new parents may be retaliated against because of taking advantage of even the leave policies that employers put in place for the benefit of their employees, that they're not expected to use it, or if they do use it, they may be looked upon very differently, or maybe in fact retaliated in a variety of ways. Again, loss of advancement, loss of opportunities, loss of being given plum assignments within the law firm or within the business. How big a problem do you think that is? You earlier, discussed a bit the so-called mommy track, but there is also, I guess, the corollary to that, which is the daddy track, which is that men historically been expected to get their rear ends right back in their desk chairs and get back to work. How in 2019, where do we find ourselves in the labor force when it comes to these kinds of issues, in the way new parents and not so new parents may be retaliated against in some of these more subtle ways?
Sure. So what we know with respect to men who take on primary caregiver roles is that they certainly feel like they are viewed differently, that they are treated differently in the workplace. I will say that there's not a lot of labor market data to support the fact that their fears are substantiated, but certainly there's a lot of survey data backing up this sort of widespread fear and concern among fathers who take caregiving roles with their children, that they will be, looked differently upon and not be able to advance quite as much in the workplace. Now, with respect to women, which of course we know that, again, as I said earlier, women continue to be the strong majority of primary caregivers in this country. That's a big explanation for the persistence of the gender gap in pay. To the extent that we still have women, or fewer women than we would expect at the highest levels of employment, a big explanation of that is because the women who are in the best positions to seal the gender gap, the women who went to law school and became Supreme Court clerks, for example, like the mother in this Jones Day lawsuit. What happens to a lot of these women is once they become mothers and if they become the primary caregiver, they do get on a mommy track, whether that's in a law firm or some other type of firm. And, they may stay working, they may still be a lawyer, but then they get on a non-partner track. And so they never reach the highest levels of the firm. They don't become the managing partner of the law firm, or they don't become the VP of the bank. They sort of stay at a mid-level management position. And so, I will say that most economists who work on gender labor market issues think that this mommy track is a big reason why we still have a gender gap in both in pay and in occupations, just simply because primary caregivers are continually routed into a different career track than secondary caregivers.
Right. And some of that, of course, can be a matter of choice. And you mentioned earlier stay-at-home dads. I mean, that would have been unheard of, years
right.
ago, and now it's a lot less unheard of. I don't know that we
right.
can say it's common yet, but it certainly is something most of us have at least heard of, or may know some people that have gone to part-time status, so they can spend more time in a child raising role. But in those cases where it's not a matter of a couple's choice, that one parent will go part-time or one parent will take a less, a lesser role, one not seeking perhaps the higher levels of advancement as a matter of a decision made within that marriage or within that relationship relating to child raising decisions, where it's not a choice, and it's more of a fear, or perhaps more of a very well justified fear. How do we deal with that?
So, the idea of choice and choosing who's going to be the primary caregiver, it's not always so clear, especially when you're talking about lower and middle income individuals. A lot of times, the choice is just simply based on finances, who makes more money, or I don't make enough money to justify paying for daycare, that sort of thing. So, the idea of choice in and of itself can be tricky. But look, I think that we're in a better position than ever to support equal caregiving and getting rid of this whole primary, secondary caregiving model, because workplaces are becoming increasingly more flexible, right? Because of telecommuting, computers, the internet, et cetera. I mean, look, we're always going to have some jobs. I always use the example of, like a front desk receptionist, that it's going to be a while, or it won't be quite the same to have somebody, telecommuting, right? There's always going to be some jobs that don't that are going to be more difficult to introduce the sort of flexibility provisions. But most industries are increasingly becoming more flexible in terms of where you work and when you work. And to the extent that businesses can introduce and support their employees' ability to be flexible in terms of when and where they work, it's going to help support equalized caregiving. And I'll also say there's actually data to support this. So Claudia Golden, who's an economist at Harvard, wrote a paper about 5 years ago finding that the gender pay gap is actually narrowest in these more flexible industries, technology-based industries, or that take industries that take advantage of technology. And her hypothesis, and I think many economists' hypothesis is that this sort of increased flexibility, allows you to be a caregiver, and allows both parents to be a caregiver, and we can just abolish this idea of primary caregiver altogether. Eventually, that's the hope.
Well, it's fascinating, and I know, again, as we mentioned at the beginning of our conversation, something that you've focused on, and I note in your bio the article that you had mentioned you wrote on this topic is called "The Pregnancy Penalty," which you had published in the Minnesota Law Review just last year, and there's a link to it on your bio. If it's okay, we can include that link in the description for this episode if people want to take a look at that article and get some more information about your research on this issue, and also a little more background on you as well. Jennifer Bennett Shinall, Associate Professor of Law at Vanderbilt Law School. I have to admit, I watched the Georgia-Vanderbilt game this week, and I'm sorry, Vanderbilt, that the Bulldogs had their way. But not sorry. Sorry, not sorry.
We're used to it at Vanderbilt, unfortunately.
Well, my wife is a Bulldog, so I'm a Bulldog by marriage, so I had to get that in. But thank you so much for being on the program and for discussing this with me and with our listeners. It's an issue that men and women across the country are deal with every day, and we'll be paying close attention to what happens with this Jones Day case as it works its way through the courts. So thank you again, Jennifer. I really appreciate you being on Good Law, Bad Law.
Thank you so much for having me.